Hi, this is City Attorney John Russo for Oakland, California, and this is another report that we're doing regularly on important cases that our office is involved with for the public to know what it is that we do and what those issues are that are impacting the city in the courts and in the various legal systems. And to help you understand, it's important that we show you some really compelling visual information.
My view is also that nobody is above the law, and if there are clear instances of wrongdoing, that people should be prosecuted just like any ordinary citizen.
Police, politicians, top county and state officials, even judges, all accused of illegally getting paid to play. The FBI says corruption is on the rise as the economy worsens.
The more resources we throw towards the problem, I think the more corruption we're finding.
Nearly 1,200 federal, state, and local government officials have been arrested for corruption in the last 2 years alone.
Starting today, every agency and department should know that this administration stands on the side not of those who seek to withhold information, but those who seek to make it known.
This is a commitment to true transparency, not only in the reforms, but in how we get to those reforms.
Oakland City Attorney John Russo, the quintessential mayoral wannabe, has committed political suicide and can never win an elected position with the revelation of undeniable evidence of criminal wrongdoing, as protests and demands for a resignation and payment of damages are insurmountable and gaining meteoric momentum. In documents filed in Alameda County Superior Court and the State of California in the Al-Hakim versus CSAA and the underlying rescue Reuter case, there is now irrefutable evidence that specious Oakland City Attorney John Russo and the City Attorney's Office has been charged with and committed extrinsic fraud, fraud upon the state, subornation and solicitation of perjurious testimony, providing litigation case files and evidence to defendants, spoliation of evidence, fabricating evidence and planning fabricated evidence in the litigation case files, attempting to deceive the public in support of the defendant's litigation theory, calumny deceit, has committed patterned, willful, criminal, fraudulent, and corrupt deception, fraudulent concealment, committed willful, criminal, and corrupt perjury, perjury by omission, made knowingly false statements, collusion, conspiracy to commit fraud, conspiracy, corruption, corrupt misconduct, prejudicial misconduct, obstruction of justice, bad faith, denial of due process, abuse of discretion, gross negligence, bias, prejudice, incompetence, and a conflict of interest.
The events of the past several weeks have shaken the public's confidence in City Hall. Not only that, the latest controversy stirring up City Hall has been an unnecessary distraction and a huge waste of taxpayer resources and time. Resources and time that should have been spent addressing Oakland's many urgent needs, public safety being first among them. Regardless of whether recent allegations against the administration have any merit, there are systems missing in Oakland government that should be protecting us against the kinds of abuses we are hearing about. People are sick of hearing about unethical behavior, nepotism, and abuse of power in Oakland. And people have a right to be angry. And speaking for myself, I share that anger.
The fraudulently fabricated and planted evidence and the witness testimony based on this planted evidence in the Al-Hakim versus CSAA case was created through extrinsic fraud, with accompanying testimony procured through admitted, suborned, and solicited perjurious acts by Oakland City Attorney John Russo and others. They engaged in actions to destroy the litigation case of Al-Hakim. They engaged in acts to cover up their unlawful acts. They committed, aided, and abated this criminal activity with the city attorney giving the case files to defendants Steve Barber and Ron Cook, whom absconded with the files for nearly a year, was an unpardonable breach of the chain of custody of the court files. Then clearly constructed fraudulent fabricated evidence in 1999 and planted that evidence favorable to the defendants in the files 6 years after the case was closed. They engaged in spoliation of the remaining evidence of the court files from 1991. During the trial, testimony revealed that there were numerous documents and photos of a very damning nature to the defense and CSAA that were missing, altered, or incomplete.
Got a series of documents from the city litigation file for the panel members.
And I didn't plan on using this document, but since the issue came up, this is handwritten notes that appear in the city litigation file.
I'm trying to determine who wrote this and if they were there. Obviously, they weren't. I don't know who wrote this, but this is obviously incorrect. I don't think you, Mr. Banks or somebody would have to write something that says this, you know, and that was impossible. I have too many people who were there that saw what happened. You're talking about fecal matter behind the bar?
Refrigerator.
The bar refrigerator?
Yes. There are photographs of the refrigerator behind the bar in the city's litigation file.
Is there fecal matter in the photos? That's simple enough.
I'm just going off the eyewitness account that appears in the city litigation file.
Well, so this doesn't look like an eyewitness account to me. This looks like somebody's notes from whatever they may have been told or thought or felt or derived at. There's no quotes here. There's nothing, and obviously there's not one single person who could have made these statements, including me.
Well, you say we say there's not one single. You couldn't even remember.
If you read this information, this is somebody's notes based on something that they either thought or was told. There's no quotes, so there's nothing that they were told. They're just trying to recap something. This could have been written 6 years later. Who knows what this means?
It's not even attributed to a specific person.
Yeah, right. I mean, it's just nothing.
John Russo has always maintained in his own written documents to Al-Hakim that the case files were requested for review in late 1999 and placed at the city attorney's front desk, although no one came to review them. These court records somehow disappeared for nearly a year without city attorneys investigating who had them, when they got them, how they got them, and why they had them. Al-Hakim contacted John Russo in the city attorney's office several times by registered mail, phone, and fax regarding their independent knowledge of the defendants absconding with the files from the city's possession, and if such action was with the permission of the city attorney. Russo has failed and refused to effectively respond and has always denied knowing who made the request to review the files or what happened to them, while Al-Hakim and his attorneys Mike Michel and Jeff Fackler have attempted several times to obtain copies of the Oakland City litigation file from January 2000 to June of 2000 and was told by the city attorney's office that the file was missing and was last requested by defendant Ron Cook.
The city's litigation file apparently has been in the hands of CSA for some time. It's been missing. We've never seen the file. But
finally, after 6 months, in June of 2000, Anita Hong called to notify Mr. Michel and Mr. Fackler that the file had been returned and was available for viewing. At that time, Mr. Fackler and Michel was told that the file had been returned by CSA attorney. Al-Hakim called Ms. Hong and was told the file was back and available for viewing, and when asked who returned the files, she responded it was returned by Stephan Barber of Roper's Majeski.
You have crossed the line into full-blooded, fire-breathing, stop the black guy at all costs racism. Go the whole distance. Get a hood. And
is Oakland City Attorney John Russo above the law? Russo and the city attorney's office should be prosecuted for clearly constructing fraudulent, fabricated evidence in 1999 and planting that evidence favorable to the defendants in the case files 6 years after the case was closed. They engaged in spoliating the remaining evidence in the court files from 1991, provided the entire case files to defendants Stephan Barber and Ron Cook, whom absconded with the files for nearly a year, and after this unpardonable breach of the chain of custody of the evidence, allowed the court to subpoena the case files to make the tainted files a part of the official trial record, presented the spoliated evidence, subjected it to trial testimony, and engaged in acts to cover up these criminal litigation tactics.
Infidel! This smacks of an attempt to undermine the trial, and the people's work needs to be done.
I think it would be the best interest of the state if he resigned, because I don't think that the public can accept this anymore.
People should not take from this episode any indication that we're going to be timid in enforcing the laws, going after those who break our laws, especially those who are entrusted with great political positions. That is going to be a focus of this department under me. We're going to go after white-collar criminals. We're going to follow the evidence wherever it takes us. We'll follow the law wherever that takes us. No one is above the law.